Welcome to this special Legal AF where I'm joined by George Conway, who everybody has seen and heard over the years. George, you have been somebody that we've been in awe of because you're a conservative, Republican who's been very, very outspoken and vocal about Donald Trump for years, even raising the alarm bells way before many others were, and warning people about his dangers and his just psychology, if you will, and why he is just a different animal than any of us are used to. So I'm so thrilled that you are willing to join this pod. I mean, your credentials are beyond impressive. You know, Harvard, Yale educated, worked for many, many years as a lawyer. You were up for being Solicitor General, which is code for anyone out there. If you're going to be a Solicitor General or you argue in the Supreme Court, you're the smartest of the smart lawyers. And so you just have you've had an incredible career. But my favorite thing that you do and have done is you're hilariously funny, which I always appreciate. So I love following you on X and seeing what you have to say about things, because I think it makes everything better when you add a little humor, and certainly it makes this time that we're in a little more palpable.
Yeah, I don't know how we can get by without a few jokes here and there, whether it be gallows humor or not, I mean,
whatever. Yeah.
And we'll probably ramp it up when they send me to Guantanamo next year.
Yeah, well, but welcome, and thank you for joining. And I just, really wanted to get your brain on all things that are happening right now, just in our country, involving Republicans and Democrats and Donald Trump. And where do you see that we are, and where do you see a path forward for us?
That's a hard question because it encompasses so much, the political and the legal. I mean, what I think right now is we have a Republican Party that is basically on autopilot. It's completely out of control. The metaphor I've used in the past is that Malaysian Airlines flight that took off from, I don't know, was it Kuala Lumpur or Singapore, and then turned around, and instead of going to Beijing where it's supposed to go, it flew into the Indian Ocean. And it's like, this guy is in the cockpit. He's completely nuts, talking about Trump, of course. And he's flying this airplane, the Republican Party, to nowhere. And there are some people on board who are saying, well, I don't see any city lights down there. We're over the middle of the ocean. Where are we going? But most of the passengers on board, think that those guys are trying to hijack the plane. And if they actually make a move for the cockpit, they're going to get attacked. And it's just this bizarre circumstance where so many people in the Republican Party have shielded themselves. They protect themselves from reality. They either don't consume news, or they consume conservative media that refrains from telling them things that they don't want to hear, whether that be Fox News, which had to pay that $787.5 million judgment for passing on the stolen election lies, or the Newsmax, or all these other things, these other outlets. I mean, they're just brainwashed. 50 million people or 60 million people. And that's hard to reverse. But
I understand. I just have one question about what you just said. I understand the politicians who have to do it. I don't agree with it. And I have tremendous respect for the Liz Cheneys of the world, or the Adam Kinzingers of the world, or the yous of the world. Not that you're a politician, but the people who say, you know what, I'm going to put my conservative beliefs aside, or even Mike Pence, and say, I'm going to put my beliefs aside and do what's right. And we know what's happened to all of them, right? And Chris Christie's another. It
started with Jeff Flake. Remember, Jeff Flake started to say this, and he was drummed out of the Senate. One of the reasons why I started speaking out, and by the way, I'm no longer a Republican. In March of 2018, I registered in New Jersey as a unaffiliated voter, because I believed at that time, and that's what I said to people was, This party has become a personality cult. And that was March of 2018. That was 6 years ago. It's much worse now, which is just absolutely insane. But what the problem fundamentally is that they have all these mixed motives. I mean, there's fear for those who live off the Republican Party, the political consulting class and the lobbying class, and all of these people who make their money off the political system. They feel that they can't cross the majority of Republican voters. They can't cross Donald Trump because it'll basically ruin their careers. You've got some politicians who are ambitious. They want to go for higher office, and they think the only way they can do that is by dumbing themselves down and repeating lies and giving Trump a pass on things they know to be morally corrupt or legally corrupt. You've got lots of people who just don't want to admit a mistake. They just don't want to say, oh, I was wrong. I supported Trump in 2016 or 2016 and 2020. And it was a mistake, because they feel foolish. And I think that part of it is also, if you go to the mass electorate, that's a big piece of what's going on. I think part of it is, as I mentioned, the bubble, the media bubble that people have tended to surround themselves with. But I think partly the reason they partly do that, I mean, partly it's they're not paying enough attention. They're not educated enough, or they're not informed enough, and they don't choose to be. But then there are people who could be, who are intelligent and who are otherwise well informed about the world, but they shut out the things they don't want to hear because they don't want to be confronted. They don't want to look themselves in the mirror and say, wow, I support this. And so they black it out. I mean, there are just so many different mixed motives here.
But why are the American people falling for it? That's what I can't understand. Even if there's motives that you can justify with politicians, look, I have family members, I'm sure you do too, who are supportive of him. And these are people who I love and respect. And they're smart.
I do have family members, right?
And they're smart and they're educated, and they're people who I love and respect. And for the life of me, I can't understand it. How do you explain that there's so many people out there who are willing to follow this, and who are believing there are things that he says that are just objectively not true, and they don't care.
Right. And I think that I think partly there's a lot of kind of narcissism in the country, and a lot of anger about life in general that finds its way into the political world. And people, there's a certain part of a lot of individuals, and this is getting into sort of psychoanalysis of cults and cultish behavior, where people need to feel part of an in-group, and they have a need to sort of hate an out-group. And that's part of what's going on. And part of it is it's simpler to accept the words of a fearless leader than it is to actually think things through and think out the nuances and think out the qualifications, and then challenge your own views when your own views are challenged by the facts. That's hard work, and it's also, it's also humbling work, because you realize in life, I think most people should, I think you get wiser and more mature as you realize how you've been wrong about things, and how your perceptions were wrong, and how your judgments were wrong, because we all, being imperfect beings, make those mistakes. And I think the people who mature over the years are the people who accept that they've made mistakes and try to correct them. And the people who are fearful of being called out for making mistakes and want to be in denial of having made those mistakes, those are the people that we are seeing, I think, who fall for Trump, to my mind. But it's not, I don't want to say that it's any one thing. I think there is cultural resentment that's a part of it, where people feel that other people in the elites in the Eastern universities, or this or that place, look down upon them because they're not perceived to be as smart or as educated or as having as much class or this or that. And I think there's just a lot of resentment there that finds its way into the political culture in a manner that just it has become irrational. I mean, we see it today the whole thing about Taylor Swift. They're picking on Taylor Swift? Why? Because
That's insane.
It's like she's a pop star. We love pop stars normally, and then she's seeing a football player. We love football. What's the problem here? I can't, but there's just people who just, there's misogyny involved, but it's not just the
Well, they're worried.
not just men.
They're worried.
There's just a lot. There's a psychology here, a complex psychology here. I think it's different for different types of folks, but it's all gelled into this toxic mix that I think it's going to take a while for us to find an antidote for. But I do think, you said your point about so many Americans have fallen for it. They have, but I think most Americans have not. And I remain hopeful that in the fall, common sense and normality will prevail, but we will still have a problem going forward with a large section of the American public who just doesn't want to face truths about things. And the truth about things is not, they perceive an alternative universe, an alternative world. I won't say alternative facts, but that is, everything's worse to them than it actually is. And things that are actually bad, they ignore. And it's like, we live in this country that is, I'm not just talking about the jobs report today that was terrific, but we live as comfortably and as well as a people as virtually any, leaving apart maybe a couple of Scandinavian countries this year, in human history. This should be the most content society ever on this planet. And who knows how long that would last. We don't have much to complain about. I mean, we don't have, I'm not saying that we don't have poverty in this country, and we don't have racism, we don't have problems, but compared to, and again, leaving apart the MAGA part of it, just on a day-to-day basis, the way people live their lives, everyone has cell phones and everybody has this and everybody has that. And we don't really see that many people starving on the streets or in Appalachia. It's certainly better than it was 50 or 60 years ago when Lyndon Johnson started the war on poverty. We have very little to really complain about. We should be grateful, and yet we have a large section of the population that feels aggrieved that things are getting worse. Things are getting worse for them, for their children, and they need, and the way they plan to solve that is to basically destroy everything. I mean, did you see that article in Politico about a week and a half ago? It was right before the New Hampshire primary, and it was Michael Cruz, a fine writer at Politico, interviewed a Republican voter in New Hampshire who was a formerly in the Marine Corps. I think he's a reasonably well-off individual and not a dummy. I mean, he doesn't have a PhD in politics from Oxford, but he's no dummy. And Cruz interviewed him on his views about things and why he decided to vote for Donald Trump. And basically, there were no real policy issues that were of any seriousness. I mean, a little harping on immigration and things like that, but it was more about resentment of other people. And he wants to you got the sense that the voter perceives other people out there as thinking they're hoity-toity and they're better than him, and he wants to wreck them and ruin their lives. And then the question came back to him was, well, and he said, and basically he thinks Donald Trump is the wrecking ball that will help, get these people. And Cruz basically asked him, well, won't that hurt you too? And he goes, yes. It is just this bizarre, self-defeating, nihilistic mindset that is, frankly, to me, not fully explicable. I mean, I can describe it. I can trace some of the resentment of educated elites, the resentment of minorities, the resentment of people in the media, the resentment of politicians, but it is just this bizarre angst and anger that really has been channeled by Donald Trump as if though through a prism, and it's focused directly on our legal and political and constitutional system and the rule of law, which is the thing that really makes this such a dangerous moment in our history. I'm rambling on there, but
no. But pivoting to the legal issues, which I know people are going to want to hear your perspective on, I want to ask you a couple of questions. So, the historic verdict in the E. Jean Carroll case, and the reason I say historic is because he only got whacked with a $5 million verdict for rape and the major defamation, right? This is now this $83 million for the first defamation, right? And then the punitives is just I think that was a massive message being sent to Donald Trump, which is ridiculous, right? I'm going to say it 1,000 times, I'm never going to stop. Well, guess what? Right. It stopped.
For now.
For now. Well, a lot of people have a question. Number one, is she ever going to see the money? Number two, is he going to have to put up the money if he wants to appeal? Number three, when will she see the money? And number four, can it be paid by his supporters, the super PACs, all the the grifting he does off of these cases? Is he going to have to pay this money, or is it going to come from somebody else?
Well, that's a good question, and I'm going to confess I haven't delved deeply into all of those questions, but to take them in order and actually start with your description of the judgment, which was accurate. I was not surprised by the size of the judgment. And if anything, I thought it could have easily ended up being higher, which is not to say that it wasn't a remarkable judgment, a remarkable verdict, and an amazing achievement and a terrific thing overall. But he was hit with the $5 million judgment, as you note, in last year, and $2 million of that was from the claim that she was able to bring under the New York Survivors Act for the actual sexual assault in 1996. And then the other $3 million roughly was for the defamation that he engaged in, the defamation of her that he engaged in after he was president. And those cases were separate because they didn't happen while he was president, because the Survivors Act wasn't enacted until after he was president. And the first case was just for the initial defamation when he was president. But if you look at the $3 million that the jury awarded for the second defamation, you could infer from that, and I always did, that any judgment for defamation from the original 2019 libel when he was in the White House has to be several times greater, because it was the initial false statements about her. And, it's like my mother always used to say, first impressions matter. And that was the first lie. So it absolutely did the most damage. And also, although he wasn't engaged in his official capacity as president when he was first libeling her in June of 2019, the fact remains that because he was at the time president, his words, his lies were amplified. So I always felt that the judgment, just in terms of compensatory damages alone, was always going to be several times higher than the initial verdict for the post-presidential libels. And that was consistent with the evidence, because they put on evidence that they would take $10 million to repair her reputation, and she suffered $10 million in damages. And then the question of punitives comes up, and here you could not have created a better record for punitive damages if you were writing a fiction novel, if you were writing a novel. a John Grisham novel. I don't know who would be writing it, or Scott Turow, or maybe us someday. We'll team up and write something. And so you've got a guy who professes to have billions of dollars, and you've got one of the most. You've got that, and you've got this continual drumbeat, including after 2022, going into 2023, going into 2024, and during the trial itself, continuing to libel her and muttering about how this was a witch hunt in the courtroom right in front of the jury. I mean, you could not build a better case or construct or imagine in your fever dreams a stronger case for punitive damages. And so, when you look at punitive damages, I think a general rule of thumb is they're not excessive if they're, any up to 7 or 8 or 9 or maybe even 10 times the compensatory. So easily, if you have $10 or $20 million in compensatory damages, my thinking was, well, okay, multiply that by 5, you're up to 50 or 100. You multiply it by 6, you could get, if it's 20, you could get 120. And I told someone the day before the verdict came down that I thought it was quite possible that there'd be a verdict of anywhere from 75 to 125 million. And, but it's one thing to say that and to do that intellectual exercise in your head, and another thing entirely to actually see it happen. And in that sense, it was not surprising, but it was staggering for me, and emotionally staggering, because I know E. Jean Carroll. I met E. Jean Carroll, and I just, as a matter of just a pure serendipity, I was the one who first told her that she had a libel case, because she asked me at a cocktail party the first time I met her, like, what do you think? And I had written something in the Washington Post about her credibility being greater than credibility of some other alleged victims. And she thanked me for that. And she said, well, some people say I should sue. What do you think? And I didn't tell her that she should sue, but I said, well, if you choose to sue, you've got a claim. And then that was just an instantaneous reaction. And then the instantaneous next thought was, oh my God, this is perfect for Robbie Kaplan, who I had gotten to know in 2018, 2017, 2018, we'd become very good friends. And so I sent an email the next day. And so thinking back at that serendipitous flash of insight that I had that one evening in July 2019 when I met E. Jean, and then to see it blossom into this absolutely colossal judgment that really is the first occasion in Donald Trump's life, really, where he's really been forced to face the consequences of his own actions. I was moved to tears. I was, and also considering Jean's just bravery, and just, she didn't crawl back and curl up into a fetal position in a closet. I mean, I remember when I met her that day at that cocktail party in July 2019, she was a very composed, very dignified, great sense of humor, very just really well put together woman. I had no idea she was pushing 80. I thought she was in her upper 60s. I mean, at most. And I'm looking, but you could see the weight on her shoulders of what, and the way, and then you see the way that she was just abused by Trump and Alina Habba. Basically, they're saying, well, you shouldn't get any damages. You brought this on yourself. You brought this on yourself by telling this story. It's like, this is the classic narcissistic trick psychologists call DARO: deny, attack, reverse victim, and offender, where you basically say, hey, and narcissistic spouses do it all the time when they engage in abuse. It's like, why did you make me do that to you? And that was essentially it was obscene, it was malicious, and this jury saw right in front of their eyes. They saw the horror, they saw the the inhumanity. They saw the contempt that he had for the rule of law, the court, and them, and us, and Jean Carroll especially. And when you think about it, it's actually very overwhelming that this is the way it's supposed to be.
And you love how
and
you love how Trump, talks about how Judge Kaplan, who is a lifetime appointment, who's been on the bench since what? I think he's a Clinton appointee.
He went on the bench in 1994, as we found out in the bullshit recusal motion that
right. And meanwhile, they keep blaming, Trump keeps blaming by Lewis Kaplan, and saying he's a Biden tool, et cetera, et cetera. This is a jury that decided this, a jury that
Absolutely.
Trump's lawyers agreed to and chose. They chose this jury who awarded this. So it's just crazy to me. I love Judge Kaplan's parting words to the jury, which is, if I were you, I wouldn't tell anyone you were on this jury, because it's
and you're a prosecutor. When do you see anonymous juries? What kind of cases? You see it when they're
I've never had one. It doesn't happen.
Never had one.
I've never had one. You don't have anonymous juries.
Well, you have it when in federal court they'll have them when you've got a RICO case and you've got mobsters and you've got
like a mass murder,
gangbangers and whatnot.
Exactly. I mean, it's so rare though. It's reserved for the most dangerous people. It's reserved for, and that's telling. I think
it's telling. Yep.
So, do you have any insight into whether she'll get the money? And
okay. Oh yeah. Yeah. So he got hit with the $5 million judgment in 2022, and he did something remarkable, which is normally when you either have to pay the judgment within 30 days in federal court under the Federal Rules of Civil Procedure, or if you don't, then the plaintiff who's won the judgment can go out and enforce the judgment by, attaching your bank accounts and putting liens on your homes and whatever. I don't know it's not something I've ever had to do, so I don't know what all the tricks are to that. I represented corporate clients who would just put up a bond, and that's what most people do. You put up a bond. You pay somebody who's committed contractually to pay the judgment if you don't, so that you can appeal, and you pay that person a fee, and it could be a bank, or I don't know, there are people who do this. And he couldn't get one. He couldn't get this billionaire couldn't get, or chose not to get, I think it's actually more that he couldn't get, a $5 million bond. And, the only possible reasons were he didn't want to pay the bonding fee, or he just didn't have the credit to do that, or nobody could try. Maybe the assets aren't his own. I'm speculating, but he didn't do it. So what he did instead was he wrote a check, which you can do, and deposit into this account nobody really knows about, because it's not used very often in the Southern District of New York. I don't know if other courts have federal courts have similar accounts. I assume they do. I don't know if they're called the same thing. It's called a Chris account. And I only had one occasion in my entire 30-year legal career in New York City to have to deal with it, is when a judge was giving some class action plaintiffs a hard time, and he said, I don't want you holding the money. I want this Chris fund to hold the money. And so he deposited cash into that account, $5 million. So she's going to get that money. The court will disperse that money when the appeal from that first judgment is finally determined in her favor, which I'm confident it will be at some point. And so she's got the $5 million there. Now, the problem is he's got this $88.3 million judgment. If he couldn't get a bond for that, he couldn't get a bond for the 5. He's not going to get a bond for the 88.3. And then, so he would have to come up with 88.3 in cash. And the question is, does he have that? Now, he said he's testified, I think in the New York civil action, the AG action, that he's got $400 million in cash. That's assuming it's possible he might not be telling the truth on that. Who knows? But he's got to fork out that money. If he puts it into the bank, into the Chris account, in the court account, well, then it's going to be there for her and she's going to have it. If he doesn't do that and he can't get a bond, then she can go running around, or her lawyers can go running around attaching assets. Now, the problem they might have is that those assets may not be in his name. They may be in the name of all the, his revocable trust, which and his various corporate entities that he makes intentionally opaque to, I think, to confuse people. So it's going to be, to borrow what Trump said about January 6th, it's going to be wild. Now, if there's another thing that Eugene Carroll can do to get the money sooner, or at least some of it. I mean, she could essentially sell the judgment. She could, if you have a judgment and you don't really like collecting it, you can get somebody else to collect it by basically selling the rights to collect the judgment to someone else, which would make sense for her since she's 80 years old. Obviously, it's a contingent upon her winning the appeals, but somebody, she could sell for 50 cents on the dollar and come out with $40 million and $44 million in cash. I'm just making this up, and not have to worry about the collection possibilities. And all she has to do is win the appeal. That would be the transaction. It may well be, I don't know, that she had a litigation funder who Trump made a big deal about, who was basically paying the costs of Robbie Kaplan running her extremely her small firm, a large team from a small firm, running that at a high clip for a couple of years. Maybe there's already a provision in there where she can get part of the judgment and have the litigation financer collected. I'm just speculating, but she's going to see some, I think, significant portion of this money at a minimum. I think one way or the other, she's going to get something. She's certainly going to get the $5 million.
Wow.
And then we don't even know. And remember, this is we're awaiting Judge Engoron's decision, right? And he's going to hit. There's a pretty high percentage, and I defer to you on this because you probably following it more closely than I am, being up in New York. I mean, he get hit with a $300 million judgment there, or more, or 400 maybe. And so I don't know where he's going to come up with all this money. I don't know how he's going to stave off collection issues if he can't purchase a bond. I mean, he's got real troubles just on the civil front, leaving apart the 91 felony counts he's been charged with in 4 separate jurisdictions. I like to say he's got 91 counts, 91 problems, and jail is one.
Yeah, except nobody's willing to treat him the way they would treat people who behave.
A regular defendant. Yeah, no, you or I would be in the lockup right now.
Yeah, I mean, look at what.
Anyway.
I mean, anybody. Look at Sam Bankman-Fried, right? He
opened his mouth and Judge Kaplan threw him in the pokey.
Exactly.
There's no question. Trump could, Trump should. I don't know what the equivalent of the MCC is here in DC. I don't doubt they have an equivalent, but yeah, I mean, he's lucky he's not in the pokey. I mean, it's crazy.
Yeah, I mean, it's just interesting because he pushes the envelope and he walks up to the line, and nobody's willing to.
Oh, he dances over it too. I was going to say
they keep moving it, right? They keep
moving it, right? You're right.
Because nobody wants to be the first one to do it, except, meanwhile, that's why my old office, the Manhattan DA's office, they were the first. No one wanted to go first, right? But they went first, and he was arrested, and now he's in. Now it's looking like that case that a lot of people criticize, saying, well, why that case? It's not that serious. That's looking like it's going to be the only case that goes to trial in March, it seems, because.
Yeah, I think that's true.
Yeah. Because the DC Circuit is not ruling on presidential immunity, which is really confounding. And I thought maybe you could talk a little bit about, is this, I think it was argued January 9th, I believe.
8th or 9th, yeah.
8th or 9th. Right. And it's already been on an expedited schedule to begin with, right?
Yes.
And so what is this taking long? Does it just feel like it's taking long? And what is taking them so long? What is going on? And why haven't they ruled?
Well, I mean, we have no idea exactly what's going on. And to take a step back, as you know, it takes, in the normal course of a non-expedited appeal, they can take a long time. I've had appeals take a year or two. And I'm sure you've had too in the appellate division and even in the Second Circuit, they can, you get a panel that's particularly slow. And the DC Circuit is not necessarily known to be one of the fastest courts, appellate courts in the land. But they did take this on an expedited basis. They ordered briefing be conducted with lightning speed. I think they understood the imperative of trying to preserve a relatively speedy trial, if not a trial beginning on March 4th. And then I think that's the reason why when Jack Smith tried to leapfrog the Court of Appeals and go to the Supreme Court by filing what is called a petition for certiorari before judgment, which would have taken the case out of the DC Circuit and put it straight up in the Supreme Court so it would get completely disposed of more quick. I think one of the reasons the Supreme Court denied that motion, that petition, was because they thought the DC Circuit would act with very quickly. Now, that said, so we're like 22, 23 days after argument. If the decision came down this afternoon, it still would be a fast decision by any reasonable standards, even under in an expedited appeal. And if it came down Monday, it still would be. It's just that I think the expectation was, and certainly I'll admit, my expectation was, wow, they moved so fast here. I'll bet you they started writing the opinion already, and they'll have it ready to go in a week. But that's easy for us to say because we don't actually have to write the opinions, the opinion or opinions. And it's a 3-judge panel, and there can be even if they all agree on what the result should be, there can be legitimate disagreements or a need to iron out possible differences, because you have to be very careful when you're writing a judicial opinion, because there are all sorts, every sentence that you write can have unforeseen consequences. Every time you explain your reasoning and you say more than you might necessarily have to, somebody's going to use that someday in some other case, and you have to be careful how you do it. And they're also writing for the Supreme Court, so they want to make this as bulletproof as possible. And then there are a couple of issues, threshold issues. There's a jurisdictional issue, which shouldn't change the result of there being a trial, but there's a jurisdictional issue about whether or not Trump can even have appealed the denial of immunity, because basically there's a line of authority that says that you can't appeal. You can't appeal. You can't appeal what are called interlocutory rulings in the federal courts, rulings that don't dispose of an entire case. Now, there are specific exceptions in the statutes, and then there's this thing called the collateral order doctrine, which says that if there's some issue where the court finally resolves it, it's not the whole case, but you can never undo it if you let the proceedings go further, then you can appeal that. And the argument here for Trump's right to appeal is, well, this is immunity. Immunity means the right not to actually face a trial. And if you let this trial go forward by denying immunity, you turn out to be wrong. It's not fixable if you let the trial go forward. But there's a line of authority in the Supreme Court that says that only explicit statutory and constitutional guarantees of immunity can allow this exception to the rule against interlocutory appeals to be invoked. And this is an explicit. This is something they're implying from the Constitution. Now, the answer to that is, well, if it's the Constitution trumps anything and everything, and so there has to be the right to appeal. But it's a bit of a thorny threshold issue, and I could see courts overthinking this and maybe getting bogged down in that. That's a possibility. And then you have judges are human. Not all judges are write at the same pace and think at the same pace. And there are, in every court every appellate court you ever see, every district or trial court you ever see, there's some judges who just write things quickly and dispose of things more quickly than others. And it could be that the person assigned to write this opinion on this panel is a slower person than we might want. We have no idea what's going on. This is, I've been fulminating for 5 minutes about what could be going on, but we really don't know.
And so what happens? What happens if they rule and then Trump wants to seek an en banc? Does he have a right to do that? Does that
he would have a right. Yes, he would have a right to seek an en banc, and he would have a right to petition
which means
the entire court of like 12 people. I don't know how many people are on the DC circuit. Actually, it's either the entire court. And then he could go to the Supreme Court. Now, the thing that could speed that all up, because you normally get 14 days, I think, or 14 or 21 days to go en banc, and then you've got 90 days to file a cert petition in the Supreme Court. If he used up all that time, he could easily chew up the rest of the summer with this. But the thing that's going to be driving the speed of the proceedings after the District of Columbia Circuit rules will be whether the court effectively lifts the stay by directly saying that it's lifting the stay of proceedings in the district court and allowing district court proceedings to proceed. And they can do that either by saying there is no stay, or they can just do it by issuing what's called the mandate immediately, which is basically the formal judgment that says we've decided this appeal. And if they do that,
which Smith asked for.
Yes, absolutely. And in expedited cases, in the courts of appeals and federal courts of appeals, you'll see something like the judgment of, the last sentences will be in the opinion, the judgment of the district court is affirmed, or the order of the district court is affirmed. The mandate shall issue forthwith, meaning that there's not the normal X number of days before the clerk's office finally puts out the mandate and sends the case formally back to the district court. So if the Court of Appeals does that, it can actually light a fire under Trump to force him to make an immediate en banc petition in an amount of time that's less than the allowed the normal amount of time, or to seek a petition for a certiorari in an expedited fashion. And that's effectively what the Colorado Supreme Court did in this 14th Amendment Section 3 disqualification case that's being argued next week. What they said was, you only get a stay, Mr. Trump, or Mr. And the Republican Party of Colorado, if you file a cert petition by January 4th. So yeah, that's what they did. And that moved that case really, really quickly. And that's why it's going to be argued next week and decided promptly after that. I think still the worst case scenario for the cause of justice in the DC circuit case, the DC District Court prosecution, would be they rule in the next couple of weeks, and then the Supreme Court actually decides to take the case, and the Supreme Court decides the case by June. I just can't see them letting this drag out to the fall, which would be possible if someone were determined to allow that to happen. And if the case is decided by June, there's a good chance, I think, that the case could at least start to be tried in August or September. And the real issue is, how long would it take, and would it be resolved before the election? So.
Yeah, well, it'd be interesting if he was.
But you're right. I mean, the Bragg case has been, it was the first one brought, and it does now appear. I mean, we thought it was going to be I thought it was going to be like the last one tried, because he seemed to be deferring to everyone else, and it seemed like the Mar-a-Lago case was a slam dunk. And Jack Smith brought the case here in the District of Columbia that is just against one defendant. It was a very streamlined, focused case. I would have thought those two cases would be tried this spring, but I mean, it's litigation. You can't always predict. It involves a lot of moving pieces, and you can't always predict how quickly those pieces will move to where they're supposed to move, or even get there. So,
well, speaking of Mar-a-Lago, I want to talk about that, and I want to talk about your 14th Amendment case that you just were mentioning. But I have one question about Mar-a-Lago. I was, first of all, absolutely shocked yesterday to read the ABC News report that there's a secret room at Mar-a-Lago that the FBI missed, as well as the fact that Trump changed the locks on a closet right before the FBI got there, and then he had the key, and they didn't go in there. I was just absolutely shocked. But my question for you has to do with Judge Cannon. A lot of people are just accusing her of doing Trump's bidding and slow walking this because she's a Trump appointee, et cetera. What are your thoughts on how she's handling these issues in this case?
Well, look, I mean, as you know, trial judges have an enormous amount of discretion in scheduling proceedings in front of them. And I hesitate to say that any judge is acting out of an impure motive. And I hesitate to say that it's impossible that this case won't be tried this year. Although, because of the way she has conducted proceedings thus far, I'm not all that hopeful. I would ordinarily not entertain that kind of speculation about her motives were it not for the bizarre proceedings that occurred in front of her when the case was first brought, and when they first served, actually, when she first dealt with the grand jury, the search warrant that the Justice Department had secured on the property at Mar-a-Lago, and then there was this bizarre satellite litigation where she created some kind of a special master and appointed a special master, basically a separate judge to deal with disputes that really just were not things that were any business of the defendants. I mean, the government seizes things in a search warrant, the government gets to do what it wants with them, and there shouldn't be any interference by the defendant, and this resulted in this bizarre satellite litigation that took several weeks before the indictment, and required the intervention twice of the U.S. Court of Appeals for the 11th Circuit, where they basically said, look, this guy is like anybody else whose property is searched, and if he's a defendant, he's going to be like any other defendant. Something that should have been clear from the outset. So, she starts with that black mark against her, and it's like this is really hard to fathom. This case, the Mar-a-Lago case, even though it involves classified documents and there are special procedures provided for by Congress that that require additional work dealing with highly classified documents and sensitive national security documents, and yes, she's not one of the judges who is familiar with those provisions, because they just don't get those cases in Fort Myers, or not Fort Myers, or Fort whatever, Florida.
Fort Pierce, I think.
Fort Pierce, yes, I get all my forts confused. Mm-hmm. I mean, the judges who deal with that here, most of them are here in the East, here in the District of Columbia, and I'm in Maryland, and the Eastern District of Virginia. But still, it's not that complicated, because the content of those documents, the specific content of those documents, does not matter that much. It's not, it's not the specific. It's the fact that these documents were in his possession, and the fact that these documents were, generally speaking, classified, but more importantly, national security documents, because the Espionage Act charges, which are in the indictment, don't actually require classification. They just require there to be sensitive national security information in the document. There's no dispute that those documents contain such information, and there's overwhelming evidence that he lied. He had his lawyers lie about whether he had the documents in his possession and had returned them all to the government, and then he moved them around in advance of an FBI a visit by the FBI and the Justice Department, so they would be concealed. And then, I mean, it's just the obstruction charges alone are a no-brainer. I mean, this case could be tried this is as simple as this is not that much more complicated than a nickel and dime street corner drug bust that a junior federal prosecutor would handle here in DC or in.
I agree.
In
the
New
consciousness York. Of guilt evidence,
it's just
changing the law, all of it. It's overwhelming, and it is so much more simple in some ways than the January 6th case. But
absolutely. So that, all that being said, you have to wonder what's going on with this judge, and it's highly, it's highly disturbing, and I think more attention needs to be focused on what this judge is doing and why. I think that she's managed to sort of stay a little bit under the radar screen by slowing things down, and Donald Trump is kind of helping by getting hammered in other places. So people aren't, because actually he's helped weirdly by things like the E.G. Carroll judgment, because people aren't focusing on what this judge in Fort Pierce is doing. So that's something that deserves a lot more focus. What she's doing, and And that's something we need to talk more about, I think, in the future.
Talk a little bit about now what's going on next week with the 14th Amendment and that case.
Well, okay, so on, I guess it's Thursday morning at 11 a.m., the marshal of the Supreme Court's going to say, oyez, oyez, all people having business before this honorable court. And they're going to hear argument in this case brought in Colorado by the state attorney general, no, by a bunch of individual voters. Well, I don't even know procedural posture, but basically the courts in Colorado held that Donald Trump is barred from being on the ballot because he would be barred from office under Section 3 of the 14th Amendment, which provides that anybody who takes an oath to support the Constitution of the United States, who then engages in insurrection or gives aid and comfort to the enemies of that said Constitution, cannot hold office under the United States. And by its terms, it applies to Donald Trump. And the arguments that Trump is making in the Supreme Court, and they were unsuccessful in the lower courts, are that, one, he's not an actual officer of the United States, and for that he's relying on what I think to be inapposite authority dealing with the appointments clause, where the president can appoint officers under the Constitution, or some other method can be provided if they're inferior offices. I think, there's language in some Supreme Court decision that basically says that, officers aren't elected like the president is. And people are saying, the president therefore is not an officer, but that's not.
Didn't the lower court in Colorado find the same
thing?
Right.
The first court did, but the Supreme Court did not.
Yeah.
The district court did, but the Supreme Court did not. And the reason why it's wrong is that the appointments clause only deals with officers who are appointed by the president. It doesn't mean the president's not an officer. It just means the president is an officer who's not subject to appointment, because there's another provision in the Constitution, namely the 12th Amendment and other provisions of the Constitution, that show how he's supposed to be elected, which is by the Electoral College. So I don't think that argument is very good. And there's a lot of historical evidence that people understood in 1867 or 68 when they were drafting the 14th Amendment and it was being enacted by the states, approved by the states, that people understood the president to be the chief officer of the land. And then there's there's an interesting letter that somebody, it's not really precedent, but it's an interesting letter that apparently Justice Scalia wrote explaining that, he thought that that the president was an officer. I think that's a stretch of an argument, but people seem to be taking it more seriously than I would. I think the feeling is among most people, including people who think that Trump should be disqualified under the 14th Amendment, is that the court is going to look for any way to get out from having to be the one that delivers this blow to Trump, because it's just, people don't understand it. People think, how can you knock somebody off the ballot? And, this may be the way out for the Supreme Court, people think. But then there's another argument that Trump is making, which I think is even weaker, which is an argument that Section 3, that provision I was describing, is not self-executing, that it does not stand alone. It doesn't have any force or effect unless Congress passes a law providing a method by which someone can be determined to have been engaged in an insurrection. And the problem is that's not what the Constitution says, not what the 14th Amendment says. It has a provision. There's a provision, Section 5 of the 14th Amendment, that says that Congress can enact appropriate legislation to enforce the prior 4 sections. But no one has ever held that, for example, to require that Congress pass a law so that the 14th Amendment Section 1's prohibition against the denial of equal protection by the states, which prohibits racial discrimination. No one has ever suggested that the states have the right to engage in racial discrimination, notwithstanding Section 1 of the 14th Amendment, unless and until Congress passes a law. That's just ridiculous. That would mean that if Congress repealed all of the civil rights statutes tomorrow, all the states could resegregate their schools by race, and that's just not the law. It's just crazy. I think that argument's bad.
And he
And one argument.
preposterously says he didn't take an oath to support the Constitution. I mean, that
Oh
to
yeah,
me
no,
says
right.
that.
He's preserve, protect, and defend the Constitution. He's saying that, well, that's not the same as what Section 3 of the 14th Amendment is, which says support. Okay, well, if you're the President of the United States and you're sworn to preserve, protect, defend, I mean, that's kind of supporting the Constitution, I would think. But they made that ridiculous argument too, and they're still making that ridiculous argument.
The only
What?
argument that I thought had some legs, I don't even know if he made it, but certainly others have made it, which to me is really the only thing that that made me think, I wonder if that's the case, which is, to have engaged, who's to say whether you've engaged in an insurrection, and isn't there some due process required to, and I know there was a trial in Colorado in front of a judge, it was a bench trial, and she found that he had engaged in an insurrection, and that was my only, I know there's not, it doesn't say in there that you have to be convicted, et cetera. I understand that
Yep.
a lot of people talk about that, but that's the one that feels, and again, it's a feeling more than it's a legal analysis. That's the only one that feels to me like it does seem to require some structure or some due process or something.
Well, let me, there are two lines of response to that. And the first is, I mean, there are really two separate arguments there. There's the process argument, and then there's the substance argument. And the substance argument is, what does it mean to engage in an insurrection? And personally, I've always thought that that's the only straight-faced argument that Trump has.
Why do you agree with me? Because I agree.
Yeah, and but not because I think it's right, but because, I mean, you can at least argue intelligibly and intelligently that, well, to engage in an insurrection, I don't think there's any doubt that what happened on January 6th is an insurrection, because an insurrection doesn't necessarily mean a coup. It doesn't necessarily mean a war. It means basically a violent uprising against civil authority. And that's what happened on Capitol Hill on January 6, 2021. Now, what does it mean to engage in an insurrection? Certainly, it means that if you were carrying arms on Capitol Hill, if you were engaging in violence on Capitol Hill on January 6th, you were engaging in insurrection. If you were planning and organizing some people who were on site, like the Proud Boys or whatever the names of those groups were. There was one guy who was back in a motel in Virginia, and he was organizing it all. Well, I think that's engaging in insurrection too, also. But I think Trump is arguing, and what's interesting is he didn't really make this argument that strongly in his petition for certiorari, but he moved it up in his merits brief when the time came to file a full-blown brief on the merits for the argument that's coming up. He's making the argument that he didn't engage in insurrection because he didn't engage in such planning. He didn't engage in such direct participation. Now, the answer to that would be, okay, but you invited all of these people here. You asked them to come to Washington. You told them to go up to Capitol Hill. You wanted to go and join them up on Capitol Hill to the point of you almost choked a Secret Service agent, or you did choke a secret. I mean, they're just, without him, none of this would have happened. So, that's the counter argument. But at least there is some intelligible argument saying, well, you actually have to participate. You can't just sort of encourage people to do something bad in a general sense. I don't think it's protected by the First Amendment, but I do think that he does have an argument there, and he moved that argument up to the second argument in his brief, as I just mentioned. And normally, when you write appellate briefs, as I'm sure you did, and I did, you did in criminal, I did civil. You put your best arguments first, and you basically, when you see a brief, it's like, generally speaking, you assume that the first argument is the one that the appellant believes in the most, the second is number 2, and the third is number 3. You order your points in order of their strength. And so they moved that point up, that one that we're just discussing about engaging in an insurrection. But think of the problems for the Supreme Court. Is the Supreme Court of the United States really going to want to overturn a factual? They don't normally overturn factual findings. And of all the factual findings they've ever, I mean, that they don't exist to overturn factual findings. They normally take the factual findings of the lower courts as a given, because they're supposed to be a pure court of that decides purely issues of law. At least that's in the modern iteration. So, but then they want to take. Are they going to want to take this one on and say that Donald Trump did not engage in insurrection? That's a tough one to swallow too, just as hard as disqualifying him. So I would. This is not an easy case for the court, not because I think it's legally difficult. I just think it's prudentially difficult for them, because I think that's it's one of these things where, and it goes with judging, is sometimes you have to do stuff. The law makes you do stuff that it's kind of scary to have to try to do. And so we'll see whether they have the courage to enforce the law. And particularly, and I don't think this is necessarily going to be conservative liberal split, because we've seen commentators out there, we've seen liberal commentators saying, oh, this can't possibly happen. And we're seeing conservative commentators saying, like, Judge Ludig or me, saying, well, this is the language of the statute, and we conservatives believe in the language of the Constitution. It says in plain terms what it says. And, like it or not, we have to apply it that way. And that's sort of going to be an interesting dynamic in the argument on Thursday, which is the textualists and the originalists on the court, the conservatives, the best arguments against Trump are textualist and originalist arguments. Hey, look, it just said this. You gotta apply it as it's written. You can't find a clever way out, the way liberals found clever ways of reading all sorts of things that you didn't like into the Constitution over many years. So it's sort of like it's sort of an amazing test of people's fundamental views of jurisprudence. And I would not, even though I think that the legal arguments run strongly in favor of the plaintiffs, I would not put money on this case. I would have put money on a lot of other things, but not this case.
Is it going to be a audio? Are we going to be able to hear the audio next week?
I think they're going to run. I think that, as the court has done in normally what the Supreme Court does is they don't allow cameras in the courtroom. They do record all of their arguments. And typically what happens on an argument day is the argument is recorded, and then, it's a 10 o'clock or 11 o'clock argument most of the time. And then by 1 or 2 in the afternoon, they post both the transcript of the argument and the tape of the argument. In cases that are of exceptional public interest, where there's just overwhelming media interest, they will do a live stream. And I think they also did it during COVID because of COVID. And in this case, they're going to have, this argument is going to be live streamed, and you probably can be able to turn on CNN or MSNBC or the medium of your choice. You could probably log on to the Supreme Court website, and you can listen to this live as it's happening. You won't be able to see the smiling faces of the justices or the counsel, but you will be, at least on probably CNN and MSNBC, you'll be seeing these sketches of them.
Yeah, well, you'll be able to see it on the.
Do you ever see when somebody made these Muppets of the or dolls of the Supreme Court justices, and they time them to the tape of an argument, and
amazing.
I don't know that we won't see that here, but
no, but you'll be able to get it on the MeidasTouch network too, if it's available, for sure. We'll also stream it.
Yeah, you guys are amazing.
So, George, we're coming to the end, but I want to talk about your new podcast that you have announced. Tell us about it. What are you doing, and where can we find it, and how often? I love reading your Atlantic articles, by the way. I know you're a frequent contributor, and it's a great place. It's certainly a great place for information for anybody who's looking to really.
No, it's just an amazing journal, and
it is
proud to have
And
But
yeah,
I'm
no,
proud they have me writing for it. You know, I mean, that they would
yeah,
have
well,
me.
your
So.
writings are definitely a trusted source for sure. But tell us about your podcast.
Okay, so the podcast, for a long time, people say, "Oh, you should do a podcast. You should do a podcast." And everybody under the sun, has podcasts. And I always thought, well, I mean, aren't we going to end up with more global warming with all this energy being devoted to podcasts? I don't know. And I was always resistant to them. It's like, okay, well, why does the world need another podcast? But at the Bulwark, run by Sarah Longwell, she persuaded me by promising me that I wouldn't have to do any work. I would just have to answer her questions. And since I make it an effort, particularly because I think I sort of have a duty to do that this year, and I go on television and talk about stuff, and I'm writing about stuff. This is another way, and I bet you have this similar experience with doing this podcast and going on CNN. There's a synergy involved where you learn. Having to talk about things forces you to learn about them. And then, when I talk about something, I say, hey, well, I should write this up. Or when I write something up, I say, here, this is something I can talk about. So I said, okay, fine, I'll do this. And so what the idea behind the podcast was is that, Sarah Longwell is a political type. She runs nonprofit political organizations and so on and so forth. She's a political consultant. And she doesn't have a background in the law, and she says there needs to be a podcast where somebody explains to me, like I'm a 5-year-old, what's going on. And I don't quite dumb it down that much. I talk too fast and I talk too much, but people seem to be responding to it, and it's done quite well. And our most recent episode, we taped yesterday afternoon at 4:00, and our guests were Robbie Kaplan and one of her law partners who tried both of the E.G. and Carroll cases.
Wow.
And she told us some absolutely amazing stories about Trump's behavior at his deposition. One story was how when he found out that Alina Habba and her team had ordered, the deposition was at Mar-a-Lago. And whoever's hosting a deposition, as you know, it typically in the practice of law, they buy lunch for everybody, and they stick lunch in the conference room for their adversaries. It's just a courtesy, and it made sense here because they insisted. The Trump people insisted, his lawyers insisted on having the deposition in Florida at Mar-a-Lago. So anyway, Trump finds out just before the lunch break that Alina bought Robbie and her team lunch, and he flips out, and there's a stack of exhibits on the table, and he takes them and he chucks them against the wall violently and storms out of the room. It's an incredible story to hear Robbie tell. And then the other story.
Wait, just because his lawyer bought lunch?
Bought lunch. And then he's screaming they could hear him screaming at Alina. I mean, you almost feel sorry for Alina. Okay.
Why is she still his lawyer? Do you know what? Like, why is she his lawyer? Like, I mean, I don't want to pile on, but she just has not even the most basic level of competence. She just doesn't. And why is she his lawyer? Is this by design? Like, what is going on here?
Well, he loves people who just will say anything to defend him. And I mean, he likes attractive women. Let's be blunt about it. So those two, I think, stood her in good stead, and she basically will do whatever he tells her to do, including things that got her in trouble before the judge. That said, he posted on Truth Social a couple of days ago that he was now interviewing appellate lawyers to overturn the Carroll judgments. So she may be out. Maybe he finally had enough of her. I have no idea. Who the hell knows? I mean, people go in and out of Trump world for reasons you can't even fathom on a day-to-day basis. And so we don't really know. And the other story, I had to tell the other story, which is pretty wild. Not necessarily, you can't really tell it on a family TV network. But at the end of what happened was there were two depositions that were essentially back to back, 1 week to the other. One was in this pyramid scheme case called ACN, and Robbie represents the plaintiffs there, and the other was in the Carroll case. I forget which one was first, but at the end of the first day, Trump and Alina, as they are leaving, Trump says to Robbie, see you next Tuesday, referring to the next deposition ostensibly, except the deposition wasn't on Tuesday. See you next Tuesday. I'm not going to say what that means.
Well, no, it's I think most people
I had only
means.
heard it like once or twice in my life. And when I first heard that story from Robbie, and Robbie didn't know what it meant. And she just was puzzled, like, why are they talking about Tuesday instead of Wednesday? And then basically one of her associates or partners had to explain in the car ride back to the airport, Robbie, this is what this means.
He just called you a terrible expletive name for
a very, very misogynistic term.
Yeah, for those of you who are listening who don't know, I hate to tell you this, but it's the letter C, the letter U, and then next Tuesday. And it's a very derogatory way of calling a woman a terrible name. What a disgusting, I mean, he is
he's a pig.
He's a pig. He's, it's really
who would do that? I mean, it's just beyond. I mean, it's he's just repulsive. And to think this man was president of the United States. I mean,
and to think that he's going to potentially be again is what I just, for the life of me, I don't understand. I mean, as I tell everybody, and again, I'm not political and what do I know, but I kind of feel like, don't people know if you really hate Joe Biden, who I love, by the way, why don't you just make Nikki Haley your nominee? I think she could. I think people would vote for her. I think
she'd win a general election. It's completely irrational.
That's so. This is like irrational. I don't understand why they don't see this because
absolutely.
And again,
that plane on autopilot. But with
it's more than on autopilot. People are doubling down. I mean, they are like. F you, F me, F me, F you, and I'm going to, it's this insanity. And hopefully they're going to fly their plane into the, into the ocean like that.
Yeah. The problem is, as you know, are they going to take the rest of the country with them? And that's the problem.
Well, what I mean by flying it into the ocean.
Yeah, I know.
That he doesn't get elected president, but anyway, I am so appreciative that you took time.
We came full circle there, topic wise, right?
Yes, of course. You got to turn it back into.
It all comes down to that.
The Malaysia Airlines, plane that we're going to fly into the ocean. No. But is there anything I didn't ask you about that you want to mention, or? No,
I don't think I ever have to say another word publicly again. I think we talked about everything. You were very comprehensive, Karen.
Any secrets, any Trump secrets that you want to reveal that, you've never told anybody?
No, I think I've told all my stories.
All right. Well, I'm so appreciative. I love your little corgi. I love your corgi in the back. The little guys. Yeah. Yes, exactly.
I should be moving them up. I don't know why. I think the housekeeper pushed them back a little bit. But
anyhow, thank you so much. And I hope you'll join us again.
Absolutely. Thanks.
Take care.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.